All right, court is calling 2026 CR 001694 State versus Jonathan Paniagua. Can I have parties announced?
Ready for the state?
And Tim Molina for Mr. Paniagua.
And are you Mr. Paniagua?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Sir, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Waiving the punishment commencement, but otherwise proceeding as charged.
Any objections?
No, Your Honor.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance penalty group 1 to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Paniagua, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 3 years in the prison. State will take in consideration 2026 PF 08579 and 2026 PF 08580. Did you understand that to be your plea?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yours.
State, any evidence?
Deputy Officer Exhibit number 1, including all of its attachments.
No objection.
State, you may be excused.
Thank you.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it
Yes,
and
sir.
sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just ask the court to follow the plea bargain.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. Take in consideration 2026 PF 08579, 2026 PF 08580, and there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, make better decisions, okay?
Yes, ma'am, I will.
All right, good luck to you. Wilson. All right, counsel, where are we on discovery?
I think we're still missing some lab reports from the lab, and then additionally, we need to switch over our discovery system. We need everything to be uploaded to the new system. And I don't know that the high school have access to that.
What lab reports are you saying are missing? What lab reports are missing?
whatever they collected at the scene. So specifically, I believe that was DNA and ballistics. I didn't see which part.
And Judge, I was able to download a huge bulk of discovery to start working through with Mr. Wilson from the old system, so we're not just waiting for that to transition. But we certainly would need another hearing, if there's more discovery elsewhere.
So the DNA ballistics, is that something that is ongoing or is that something that has been completed? All right. So one of my pet peeves is cases being indicted without ballistics, without DNA, and this is the crux of somebody's case. I don't understand why people are doing that. I actually had a case in this court before where somebody indicted a case and didn't have the autopsy report. So just wondering. So we're recalling this in 60 days. In 60 days, they need to have all their discovery and the state needs to be prepared to tender an offer. All right, what date? May 18th. All right, thank you. Do you have any questions? Sir? All right, thank you. We'll see you back on May 18th.
Thank you, Judge.
Thank you. All right, are there applications?
No.
Court is calling 2025 CR 010790 State versus Nicholas Keonis. Can I have parties announced for the record?
Luis Martinez on behalf of Mr. Keonis.
And are you Mr. Keonis? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, I did.
Court will find that the state is in compliance with discovery. Mr. Keonis, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, your state decision on the lesser included offense of attempted.
Any objections? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
The state is proceeding on the lesser included offense of attempted unauthorized use of a vehicle. That's a Class A misdemeanor. Range of punishment is anywhere from $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Keonis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
Oh, yeah.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 23 days in the Bexar County Jail. There's a $700 fine, no applications, and the state is proceeding on the lesser included offense of attempted unauthorized use of a vehicle. Did you understand that to be your plea?
Yes, I did.
Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did, Your Honor.
Counsel, have there been such motions?
There have been none, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
That's without objection, Judge.
All right, and state, have you spoken with the complainant? All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we asked to accept the plea bargain. He has 23 actual days in. So it's our intention is that the judgment would be satisfied.
All right. The court will sentence you to 23 days in the Bexar County Jail, give you credit for any time served. There's a $700 fine, time and money will run concurrent. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. And make sure you know what property you're accepting, okay? All right, good luck to you.
Thank you.
Who's here on Santiago? All right. You're going to be set for jury trial and a plea deadline date on April 27th. Is there anything else?
Nothing to say?
Not from
All right,
the-
you'll need to appear in court.
Thank you, Judge.
All right, thank you. All right, Miguel Maldonado. Hello.
How you doing?
Oh, I'm doing great. How are you doing?
Good, you?
Great. It's been a beautiful day and the weather is nice. All right, what is happening with this case? Vashawn?
Mr. Wood is supposed to be, it's a motion to withdraw.
Yeah, it was just a motion he filled in.
Oh, well, do I have the motion to
That's right.
withdraw?
This is the motion he gave me.
Oh, no, you can have it. Just a second. I think so. Yes. All right. Your attorney wants to withdraw. Do you have any objections to that?
No, no.
All right, the court is calling 2023 CR 2432 for the state, for the defense.
David Andre Woodard.
All right, this is State of Texas versus Miguel Maldonado. The defense is seeking to withdraw due to contractual obligations. Is that correct?
Correct, Judge, and client wishes for me to withdraw.
All right, state any objection? All right, and sir, you have no objections? All right, that will be granted. Thank you, Mr. Woodard, you're excused.
Thanks, Judge. Have a good one.
Oh, you too? All right, you have a contested hearing that's set for March 24th. Are you going to be able to hire an attorney?
I'm in the process of looking for one right now.
Well, I mean, your contested hearing is set for March 24th.
Well, I'll have one before then, ma'am.
All right, Norman, make sure he has the reset form for March 24th, and whoever you hired, let them know they need to be prepared for contested hearing.
Yes, ma'am.
All right, thank you.
Have a seat, we'll call you up.
Deandre Coleman.
You can box Judge Coleman?
Can I get the case number on that?
I don't have the case number. I don't have the paperwork.
I have it.
It's 2025-000464.
Is that right? Your waiver of right of appeal saying it's not.
All right, is this still going to be contested?
Yes, Judge, we could put a couple things in the record. Judge, my client and I have
We're
confirmed.
not on the record yet.
Okay.
So are you guys having a contested hearing or no?
Yes.
All right, court is calling 2025 CR 00464 State versus Deandre Lamont Coleman. Could I have parties announced?
Is that all off the record, Your Honor?
No, that's all on the record. All right, so you all will be back after lunch. All need to be back at 2. Court is calling 2025 CR 0155787 State versus Alicia Jimenez. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Sharon Thorne for the defendant, Your Honor.
Are there any applications?
Yes, Your Honor. Application for deferred adjudication.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Jimenez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not trying to proceed on count one only, and additionally, we will be waiving the repeat offender enhancement.
Any objection?
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. State is silent on your application. They're taking in consideration 2025 CR 0156767-02. There's an affirmative finding of family violence. There's to be the appropriate places. All right. You're not allowed to appeal unless your attorney has filed pretrial motions and the court has ruled on those pretrial motions, and you're waiving those rights. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objection, Your Honor.
And state, have you spoken with the complainant?
Yes, we have.
All right, state, you may be excused.
Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Counsel, it takes, I think, 6 to 8 weeks for PSI and TAP evaluation. So we can give you a date in 6 to 8 weeks, or if you would prefer, y'all can come back in 2 weeks. I'll find out her criminal history and you can present whatever evidence you wish to present.
I think we need this 6 to 8 weeks.
All right, Norm, I need a PSI. State, I'll need a TAP evaluation. Is there any mental health?
No, Your Honor.
All right, what date?
April 30th?
That's fine.
All right, we'll be back on April 30th. At that time, I will make my decision based upon any evidence that's presented.
Thank you, Judge.
All right, thank you.
Have a good
Thank
day.
you, Your Honor.
All right, you too.
Maybe excused.
Yes. James Parker. Counsel, you're on that side. All right, today is plea deadline date.
Yes, Judge. Defense is respectfully requesting an additional deadline for a plea acceptance or rejection. We did receive a plea bargain agreement from the prosecutor's office. However, I didn't have an opportunity to review the videos. This is resulting from a traffic infraction on a bicycle, which I do think there might be some questions about. And until I'm able to see that video, I won't be able to know whether or not there is an issue. He also has 2 other cases that are still pending that were picked up after this offense date. Our indictment was handed down, I believe, in December of 2025. He was served with notice of the indictment in this case just last month in February. And so if we can please be given an additional setting so that we can consider the state's evidence in its entirety to make a well-informed decision about accepting the plea bargain agreement that was extended, we'd be grateful.
All right, Ms. Ferguson, recall this for March 24th for plea deadline date and jury trial.
Thank you, Judge.
Thank you. Thank you. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, who's next?
Jeremiah Mark, page 1, 3 down.
Jeremiah Martin.
Morning, Judge.
Morning. You're
Mr.
on that side. Where's your client?
He was last seen in Harris County January 16th, 2026. He was arrested on this warrant down there. Bexar County was notified and did not fail to pick him up. He was granted a PR bond and released.
All right, court is calling 2025 CR 004009 State versus Jeremiah Mark. Could I have parties announced for the record?
Kurt Hopke for defense.
All right, the defendant did not answer docket call. This hearing was scheduled at 9 a.m. It is now 12:20 p.m. The court had this set on March 16th. The court recalled it for March 18th. The defendant did not appear. Then the court recalled it for today. The defendant has not made an appearance. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not out there.
All right, defense, do you have any idea where your client is?
I think he's somewhere on the streets of Houston, Texas, Judge. He was released from Harris County on January 16th on this warrant. Bexar County failed to pick him up, so now he is in the wind.
All right, the court will issue a judge's warrant, remand your client without bond.
I believe there already was a warrant, so
Well, we'll see. Thank you.
thank you. Jeremiah Mark.
All right, who's next?
Alexander Patino.
What page is that?
He is on page 7, 3 down, Judge.
Alexander Patino.
He's present.
Yes.
Okay, so the minor changes to that court summary is Mr. Patino actually did complete his defensive driving course as well as his intensive outpatient treatment. He is up to date on all of his court cost fees and any other fees associated with probation. On the court summary, it did indicate to continue with probation due to him not completing those items. However, we received all the information that we needed this morning, and both his officer and the manager are okay with early termination.
All right, and state you're opposed. All right, court is calling 2014 CR 10692 State versus Alexander Patino. Could I have parties announced?
Your opinion for the state of Texas.
Jesse Sepulveda for Alexander Patino.
And are you Alexander Patino?
Yes, ma'am.
All right, you filed a motion for early termination off the record. My understanding is that you've completed everything. Is that correct, State?
Yes.
All right, and State, I'm assuming you're objecting to early termination based upon the nature of the charge?
Nature of the charge, the fact associated with the charge, the fact that the defendant had some violation reports submitted while he was on probation. We picked up the charge that he was on probation for this offense. And also we were unable to make contact with the mother of the child to get her thoughts on the matter.
All right, defense.
Your Honor, on behalf of my client, we respectfully request that you terminate this early. He's been on probation initially on deferred since June 8th of 2015. He did violate, but you sentenced him to TDC for 6 months and brought him back on shock probation. I mean, I believe he was punished for that. And then he did have a DWI. I believe that is going to expire on April 1st. So he has had some mistakes. He's, I believe, paid for those mistakes. We're asking if you would, he's been in substantial compliance. He's up to date. He's done everything the court has asked him to do. And there are two other reasons, Your Honor. There is a no contact order with minor children. Mr. Patino has had a daughter who was involved in this case, and he had no contact with her for 8 years already. She's going to be 18?
She'll be 17 next month.
She'll be 17. She had no contact with him. I mean, essentially terminating his rights. He's paid child support. He's met his responsibilities. He's also got a 4-year-old child who is not able to see because of that no contact order. She wants to have a relationship with him. He wants to have a relationship with her. Because of everything involved, all the facts and circumstances, we respectfully ask that you terminate this.
Okay.
It's been
Well,
a-
say, it appears that he's completed everything. What have you learned? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. What have you learned?
To do what's right and to not make mistakes.
Well, these are not really mistakes. These are choices. So what have you learned about choices?
On their decisions. And to think about what I'm doing a little bit more before I act upon anything that could be taken as a mistake or as a wrong decision.
All right, he's completed everything. There's nothing else that the court can do. I did address the DWI by having him do VIP live here, monthly UAs, 120 sober support meetings in 120 days, which I'm assuming he completed, because otherwise we wouldn't ask for, the probation would not present me with a document saying that they agree to early termination. So the court will grant early termination.
Thank you, Your Honor.
Thank you.
Thank you,
That
ma'am.
would be excused.
Yes. Christopher Irving. All right. Hi.
Good morning.
Morning, Your Honor.
Morning. So, where are we? Discovery.
May 18th.
All right, we'll be back on May 18th, and y'all let me know where you are on discovery.
Yes, she filed a motion to amend bond conditions. We have an agreed order.
There's a copy of our motion, Your Honor, and the agreed order on top.
All right. All right, with this order, you're only allowed to go to work. So the way GPS works, if you're driving and there's a McDonald's and you're like, hey, I want to stop there and grab something because it's on the way, you're not allowed to do that. GPS will show that you're doing that, and that's going to be a violation. You understand?
I do, Your Honor.
All right. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome.
Have a good day.
You're welcome. And you can take a photo of this if you need to.
Yes, Your Honor. Do you want me to take it to the back or? to the back
No,
to
you can give it to her. All right, court is calling 2025 CR 015070 and 2025 CR 014076, State versus Alfredo Garcia. Can I have parties announced?
Ray Lopez for the defense.
And are you Mr. Garcia? Are you Mr. Garcia? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the true bill of indictments with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each cause?
We are.
Mr. Garcia, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
And the cause number ending in 70. In both cause number, you're charged with possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
So did, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter into these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, according to the plea bargain agreement, punishment is to be assessed under 1244 at 124 days in the Bexar County Jail. There's an $800 fine. The cases will run concurrently. The state is taking in consideration 2025 CC 01376 and 2025 PF 28869. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge, Roberts takes exhibit number 1, including all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver paragraph? I'm sorry, did you review the waiver and stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments and the cause number ending in 70, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Court will sentence you to 124 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. Take in consideration 2025 CR 013767. And this will run concurrently with 2025 CR 014076. All right, and that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And counsel, is this supposed to be a judgment satisfied?
It is, Your Honor.
All right, the court will show that the judgment is satisfied. Next, we're going to proceed in 2025 CR 014076. 076. And that cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Court will sentence you to 124 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 015070. Take in consideration 2025 PF 28869. Court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better decisions, get help, okay? All right, thank you.
Thank you.
Thank you. Who's next?
William, page 4, 3 down. Melania Williams.
Melania Williams. All right, where are we on discovery?
Your Honor, we have received all the discovery in this case. This is a first setting. We just got an offer, so we could just do a 30-day reset. That should be sufficient.
How old are you? 17. Norma, set this for a plea deadline date in 45 days, please. All right, once you sign the reset form, you're excused. All right, good luck to you. Who's next?
It is, Pearson, page 2, 1 down.
Pierce Pearson. All right, hi, so what's happening?
So I did talk with Bianca, and I also talked to the ADA assigned to the court this morning. It's relayed to me that she needs to run it by the chief.
Okay.
And she expects that she'll be able to do that in about a week or so.
Okay.
And so we're asking for another reset.
Okay, I'll give you a reset. I'm so sorry you're going through this. This is the perfect example of somebody being in the military and people just throwing them away. But you will not be thrown away in this court. I still think you should have been accepted in Veterans Treatment Court, and I'm still waiting on the statistics of who is accepted in that program, because I think you would have been a good candidate for that program. And that's based upon my experience in being in all of the treatment courts. So I'm hopeful you'll get accepted in this program. All right. So Ms. Ferguson, reset this for 2 weeks. And counsel, all right, April 2nd. And counsel, follow up with me on that court providing the statistics of who they accept in their program.
Okay, I will.
right.
Absolutely.
Thank you. All right, who's next?
Michael Rosa.
What's happening with this? Are we proceeding on the motions to revoke?
Not today, Judge. We're requesting a short reset. I'm just waiting for documentation from Lifetime Recovery. I should receive it within the week. I emailed them. I got the information from my client, and they're gonna give me all the information I need to provide to the state, and it should resolve the MTRs.
All right, Ms. Ferguson, recall this for March 30th.
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. And counsel, make sure you have probation in the loop.
Yes, Doc.
Who's next?
It is, Jorge Zamora, page 6, 1 down.
All right, there's a motion for speedy trial.
Motion dismissed for lack of a speedy trial. Yes, Your Honor.
Okay. Could somebody hand me, I don't have anything on this case. I don't have the motion or anything.
It's a motion dismissed for denial of a speedy trial. I have a copy if you want.
And state, are you opposed or?
Judge, I guess I just give some history. I mean, technically we're opposed, but at least, when we're ready, I can kind of tell you the history of where it is.
All right, court is calling 2019 CR 12366. State versus Jorge Zamora. Can I have parties announced for the record?
Steven Spear for the state.
Raymond Martinez for Mr. Zamora.
And are you
Okay,
Mr. Zamora? All right, defense has filed a motion to. All right. State,
Yes, Your Honor, just in terms of background, in the indictment, the offense is alleged to have been committed September 1st of 2016. The state did receive a case from the San Antonio Police Department. It was on November 19th of 2018. I will tell the court, and defense knows, in that receipt of the prosecution guide, it did indicate that we knew that the defendant was in federal custody at the time. I will tell you that during that time frame, until just recently, I believe earlier this year, the state did not make any attempt to bring the defendant from federal custody. My understanding is he was in custody at the time and then subsequently was convicted and placed in federal prison, which he has since been in that time. So we would have been aware of where he was, at least within the federal system, if nothing else, during that time frame. It wasn't until recently, I believe March the 9th, that we actually did bring him back over to face these charges from this 2019 indictment. He was indicted on November 13th, November 13th of 2019. So just kind of in way of history, I wanted to let the court know those aspects.
right, and so he's been in custody, in federal custody since what date?
Judge, the prosecution guide was filed in November of 18. It stated that he was in federal custody during that time when the detective was investigating it. I don't know the specific date, but at least it would have been sometime prior to November of 2018.
All right, defense's motion to dismiss for want of speedy trial is granted. Is there anything else?
Had so much testimony to put on, Judge, but that's okay.
You want to put on testimony?
No.
You sure? I'll withdraw my ruling and we can hear.
But no, I just wanted to leave, give the rendition and let you know what the facts were. So.
All right, thank you.
So.
There should be an order attached to the motion.
I've already signed it.
Thank you, Judge.
Thank you.
Mr. Zamora, have a seat, sir.
James Wilkins.
One.
Wilkins?
Your Honor, he refused to come over.
Okay. Sometimes people just want their jury trial. Does he want a jury trial? Mr. Cox, he's saying he doesn't want to come over.
Well,
I know March Madness is happening.
got it. I got to inherit the case recently, Judge.
Mhm.
So he's been in 500 days.
Oh, so here's the thing. There's mental health issues with him because he's been transferred to the state hospital before. So,
This one came back as he was competent.
mhm. So what we're gonna do is we're gonna recall this. Norma, recall this for March 30th for jury trial. And we will see if he comes over.
But I just wanted to know, Judge, that it's been in like a couple of years. I wasn't the lawyer. I got the case.
Oh, when were you appointed, Mr. Cox?
I think it was yesterday, no, Judge.
Oh, what, yesterday?
26. So.
I think most people today before you on this.
All right, Norma. Set this for jury trial for April 27th. Is that enough time, Mr. Cox?
We'll try to make it work there.
All right, who's next?
I'm sorry, Judge. Give me 1 second, please. Folks, page 7, one down.
Mr. Folt?
Good afternoon.
Good afternoon. Yes.
Judge, this case is set for trial next Tuesday. I filed a motion for continuance because Robert and I are still going through some of the discovery. We have to look at the child safe video still.
All right, so why hasn't that happened? Because this case has been on the docket since September.
All I can answer is I've had lots of other cases I've been working on that are similar to this case.
All right, this is coming back for jury trial March 30th.
Thank you.
Thank you. And Deputy Laura, he needs to be brought over dressed for trial.
Yes, Judge.
Okay. Who's here on Casanova?
Casanova?
What page is Casanova on?
He is on page 6, 3 down.
No. Oh, no, you're just completely right.
Counsel, are there any applications?
Yes, Judge.
All right. Court is calling 2024 CR 2974 State versus Hector Casanova. Can I have parties announced?
Galloway for the state.
Charles Buck on behalf of Mr. Casanova.
And are you Mr. Casanova? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Casanova, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Casanova, did you review the court admonishments with your attorney? Did you understand it?
Yes.
And sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 2, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days, 2 years in the state jail facility, and up to $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Casanova, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you were represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at $1,000 fine. There is a recommendation of deferred adjudication. State will take in consideration 2024 CC 738137. Did you understand that to be the plea? Defense, is that the plea?
Yes, Judge. We'd like to address the fine at the appropriate time.
Right. State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motion?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 150 hours of community service restitution, the driver safety course in DOEP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plea? Guilty, not guilty, or no contest? State, any evidence?
State offers state 1 and attack.
No objections.
All right, state, you may be excused. Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
On behalf of my client, I'd like to ask the court if the court would consider probating the fine. He's not able to pay that fine. I mean, it would benefit him tremendously if the fine could be probated.
All right. Sir, are you employed or were you employed?
Yes,
All right. And what did you do? What type of work?
ma'am.
Mhm. Do you have any children?
No, ma'am.
Who's your support system?
I would say my mother.
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, $1,000 fine probated. Take in consideration 2024 CC 738137, proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing in households with minors. And no unsupervised contact with minors. So how long have you been using this type of drug?
I wouldn't say too long. It's always on and off.
You know, that's one of the drugs that will, as my grandmother used to say, rot your brain. And it will cause you to lose brain cells. You understand? Of course, there are many drugs that do that, but this drug especially does that. And you don't want to be one of those people who, you know, your mind is irretrievably gone. There's going to be field visits 1 time per month for 6 months. 150 hours of 200 hours of community service restitution. 50 of those hours will be deducted upon completion of the driver safety course, which I'm going to order. Another 50 hours will be deducted upon completion of the DOEP course, which I'm ordering. So that will leave you with 100 hours of community service remaining. Those remaining 100 hours, I'm going to order weekly sober support meetings. And for every meeting that he completes, an hour of community service restitution will be deducted. Probation. Is there anything else?
You did field visits, right, Judge?
Yes.
Nothing else, Judge.
Is there anything else you need from the court to be successful?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand? All right. If you need something, reach out to probation and ask, okay?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You too.
Judge, do you sign these for the county court judges or?
No, they don't want us to.
Okay.
Mr. Escamilla, if you'll come forward, please. All right, your attorney is actually in federal court. So federal court trumps state court. Ms. Ferguson,
Yes, ma'am.
set this for the week of the 30th, that for a plea deadline date.
I think March 30th, Judge.
All right, so we're gonna bring you back on March 30th. Are you employed?
I'm a full-time student.
Ah, so what's your schedule?
Monday through Thursday, 1 to 9 p.m.
Okay. All right, so we're gonna call you back on March 30th, okay? Once you sign the reset from your excuse, and thank you for dressing appropriately.
Thank you, Judge.
You're welcome. All right, who's on Ariano Salazar?
Fernando's not. No,
And is the defendant here?
no. He's a no. He's a no show. He's a no show, Judge.
All right, court is calling 2025 CR 012216, State versus Ariano Salazar. Can I have announcements for the state? All right, the defendant was scheduled to appear today at 9 a.m. The defendant has not answered docket call. It is now 1:28 p.m. State. All right, the court will issue a judge's warrant and remand the defendant without bond.
For Judge Rules warrant.
Oh, did that? Oh, did
That's Ariano Salazar.
Yes.
All right, Juliana Teao, Alfonso Cabanas, is he still in trial or something?
He, reporting this morning, Judge, let me give him a. Oh, he was in trouble. Okay, he
Yes.
talked a lot of, sorry.
All right, so what we'll do, let's recall that for March 30th. Yeah,
He was here, Judge. He arrived a little late.
okay. Are you Mr. Teao? All right, we're gonna recall you for March 30th. Your attorney is actually, come forward. Your attorney is actually in a jury trial?
Yep.
Are you employed?
I will be as of Monday.
All right, do you know what your schedule is?
It's I believe 9 to 5, around those hours.
All right, do you know how to do Zoom?
I do know how to do Zoom.
All right, Norm, he can appear by Zoom on the 30th.
Yes, ma'am.
All right, once you sign the reset form, you'll be excused.
All right, thank you so much.
You're welcome.
Do I go back out?
Oh, yeah, they'll call you.
Just 1 second, sorry.
All right, court is calling 2026 CR 0000835 and 2026 CR 0000838. State versus Jonathan Aguilera. All right, this hearing was scheduled at 9 a.m. It is now 1:31 p.m. The defendant has not made an appearance. State. All right, the court will issue a judge's warrant, remand the defendant without bond. And 2026 CR 003-708, State versus Jameson Franklin.
Yes, the term already got the plea bargaining on the 708 was going to be dependent on his MTR.
We are also set for a contest MTR today, Judge. However, after discussing with the state and with my client, we have reached basically a resolution for everything, but we are going open on the MTR. He's going to change his plea to true.
Oh, okay. All right, court is calling 2025 CR 004-587, State versus Jameson Robert Franklin. Could I have parties announced?
Jonathan Alvarado for the defense.
And are you Mr. Franklin? All right, did you review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jameson Robert Franklin who was placed on community supervision in 2025 CR 004-587 for the offense of manufacturing delivery of a controlled substance, penalty group 1, 4 to 200 grams, on July 24th, 2025 for a term of 8 years? Is that you?
Yes, ma'am.
All right, State.
Violated condition number 1, on or about the 3rd day of December 2025 in Bexar County, Texas, the defendant Jameson Robert Franklin committed the offense of possession of controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1, on or about the 23rd day of February 2026 in Bexar County, Texas, the defendant Jameson Robert Franklin committed the offense of fraud, use, possession, identifying information in violation of condition.
How do you plead to that? True or not true?
True.
State will waive the remaining allegations.
No objections.
All right. Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, and sentence you to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes.
Court will find violation of condition 1 and 1 true. State, what are you requesting?
We're requesting that you grant state's motion to revoke, Your Honor, and sentence to 10 years. This is based on the fact that Mr. Franklin was placed on probation, and approximately 5 months later, he picked up the new drug case. This case was then set for MTR. It had to be continued because Mr. Franklin picked up new cases. Looking at the conditions of Mr. Franklin's probation, there were minimal requirements, including community service, partial GPS. That partial GPS was for employment only, and on 12/4/25, it was removed because of Mr. Franklin being somewhere he shouldn't have been and was caught with less than a gram. So
Because of this continued action of victimizing the community, and just urge that he's not a good candidate for probation and ask that you revoke him.
Judge, probation had recommended DDRF, and initially there had been a recommendation of safe P that they then changed to DDRF. And Judge, I would like to call his mother as a witness.
Okay.
She is here in the gallery.
All right, have her come up.
Okay.
Deputy Mejia, she can sit down. Oh, please have a seat. I don't take it as a sign of disrespect. Thank you. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Valerie Gonzalez Frank.
All right, you may proceed.
Thank you, Judge. Good afternoon, Ms. Franklin. You know why we're here today, right? Okay. It was already mentioned, but who is Jameson to you?
He's my brother.
How many children do you have?
6.
How old is Jameson?
It's 30.
Okay. There has been previous times in which Jameson has gotten in trouble. Is that fair? And have you seen over the course of his life the issues that he's been going through and how they've affected him? Okay. And give the judge an idea, what's your own personal background as far as your employment goes?
I'm a retired social worker. I hold 6 degrees, 4 upper educational degrees. I'm a therapist as well, with an emphasis in mental health.
And so, besides being Jameson's mother, in my discussions with you, you've been very informed as to his conditions and what he's gone through and how that's affected his life. Do you agree with that?
Yes.
Okay. Previously, when Jameson was placed on probation, he had Mr. Del Prado and Mr. Bunk as his attorneys. And during that process, was a mitigation specialist appointed and worked on the case in order to create a litigation packet?
Yes.
Okay. And you were aware of that litigation packet? You actually gave it to me, didn't you?
Yes.
Okay. Is this the litigation packet that I've shown this to the state judge? I would just ask, if I may, give it to the court for its review. A lot of the stuff that I'm going to ask Ms. Franklin is covered in this, this packet. So the packet and our discussions mentioned Jameson at a young age had an accident. What was that accident?
It was on his birthday. He had what's considered a TBI, a traumatic brain injury. He fell off a virtual motorcycle ride and suffered a series of seizures. His life immediately changed. He now has epilepsy and grand mal seizures and focal seizures.
And is that still taking place to this day, even while he's in custody?
Yes.
Besides the seizures and being epileptic, does Jameson have any other diagnosed mental health or brain conditions?
Yes.
What are those?
His IQ level is of an 8-year-old. Where the scar tissue in his brain is, he is unfortunately not a candidate for brain surgery. There's more cons than there is pros. And he is diagnosed as MR, which is mentally retarded. He has significant learning disabilities, cognitive disabilities, ADHD, ADD, a series of other mental health disorders such as can't reason too well from right from wrong, especially peer associations, affiliations. Mental health wise, if I were to diagnose him, I would definitely diagnose him today with bipolar disorder type 1, oppositional defiant disorder, personality disorder, some narcissistic disorders.
So he has quite a few different things going on as a result of the accident, but also just his condition.
Yes.
And I mentioned in the beginning, it's not the first time Jameson's been in trouble. Was there a prior incident when he was 18, when he was in the Bexar County Jail? Are you familiar with that incident?
Yes.
What happened to Jameson while he was in jail?
Oh, I've read your report, counsel.
Okay, so that part, yes, thank you, Judge. Has that severely infected her?
Most definitely, that was a secondary traumatic episode, where, he was left for dead.
And he's been to prison before.
Yes.
And leaving prison, I want to focus on that. Did you feel like you saw any kind of change in his behavior in the sense of like he had learned how to deal with these issues better? Had prison helped him at all?
Actually, no. We spoke at length about quote unquote monsters. There was many times where I would visit him on a weekly basis, and the staff would ask me if he even spoke. He was very scared of the controlled environment, and he basically just planned up as a big survival of the fittest. It just isolated himself. Upon returning home, we tried our best to seek services. He is enrolled with DARS, the Department of Assisted and Rehabilitation Services. Right now, he is pending to be recertified to be identified as disabled when the Social Security Administration to once again receive his Medicare.
Yeah. Let me ask you this. Has Jameson, you're familiar with DDRF, I've explained it to you how it's a long program. Has Jameson ever gone through a program quite like that? Like where it's almost 6 months long, it's focused on mental health, anything like that?
No, not that level.
And you mentioned to me that I think it was this week you had actually had a conversation with Jameson. I think it was either on the phone or teleconference, where he expressed to you some desires. What were those?
Actually, for the first time, he made the outcry that he needed help. As a mom, it's been very hard. You've said wear many hats, and when this happened in jail, I've seen a deterioration where he's intentionally destroyed himself. But I'm not going to offer any assistance unless he wants the assistance. Occasionally I would say, you need help. But it's a very sore subject that he didn't want to open Pandora's box until recently, where he said, my life has been put in hell. I'm just dying, and I can't save myself. He did reach out to Lifetime Recovery. Unfortunately, because he's remanded without bond, he was not quite eligible for their services. I did reach out and meet to Serenity Star, and they do have that for him. If that's something that's available for him. We discussed that at length, that he's prepared not only to want those services, but actually do all the homework. He knows that it's overdue, but it's all on his responsibility.
Right. And I think something you told me, and you mentioned it kind of in your statement just now, is that you were going to be there to help him if he wanted to help, was the key. And so now that he's asked you for help, or he's made the outcry for help, as you said it, are you willing to, if the judge is going to allow him to stay on probation and go to DDRF or some other inpatient facility like that, are you going to support him when he gets out to try and help him go through this rest of this probation successfully?
Most definitely. I don't stand alone. Jameson has the blessing of myself, his father, who's my husband, his only grandparent is my mother. We're all three here. He has two brothers, an older brother who is thriving, only 18 months older, who just moved to Louisiana. We just visited him, and he lives out in the country. Is willing to help Jameson thrive. We all parent Jameson since the age of 8 because of everything that has been thrown at him, especially after the situation in jail. We literally were told that he was going to be unschooled. So it's been a challenge the last 12 years. But we're ready for now that he's ready to open that Pandora's box to help him without conditions. Whenever, whatever the professionals suggest, we're ready to hold his hand and walk this extensive walk with.
I have no further questions, just a past witness.
State.
Hi, Ms. Franklin. My name is Melania. I'm one of the prosecutors for the state. I have a few follow-up questions. So you discussed on direct with Mr. Alvarado that Mr. Franklin has some mental deficiencies. Yes, I do. Does Mr. Franklin maintain and make his own health and financial decisions?
No.
Yeah. Does he have a power of attorney?
I have 4.
So because of Mr. Franklin's mental deficiency, his TBI, are you telling this court that he fails to appreciate the consequences of his actions?
Can you be a little bit more specific of the question?
So failing to appreciate the consequences of his actions. So if he does something, is he able to consider what may happen if I do this, then this will result? Is he not able to do that?
We do speak about that. He relies heavily on us.
Mm-hmm.
The number 7 is what works with Jameson, but he does know if I do something, there's going to be what I always say is an earned consequence, either a positive or a negative. So I feel like this done. Just know that for every action, there's a reaction. For every there's an ABCD, there's an action, behavior, choice, and decision.
But is he able to come to that? Like for every action, there's a reaction. Is he able to formulate that without discussing with you?
At times.
At times, okay. Does Jameson reside with you currently? Or
Yes.
for incarceration? Yes. And is that the same location that his grandmother also resides?
Correct.
Yes, okay. You stated that you and a lot of family members parent Mr. Franklin, is that correct?
Yes, ma'am.
At the time of these alleged offenses, do you know whether family members were home? Did y'all know about Mr. Franklin's whereabouts on the offense dates?
No, when he bonded out, I know I called the probation department. I made him call the probation department because Judge Boyd had ordered him to be on a monitor, and that did not happen. I'm a very strict parent because my son is 30. However, the problem with my peers of an 8-year-old, so a parent as an 8-year-old, not a 30-year-old. And I said, you need to be on a monitor, you're going to get in trouble. However, it was just what it does. Don't worry about it. So we've never been involved with any of these wrongdoings.
Okay, so you're telling this court then, because now Mr. Franklin is stating he wants help, you're going to implement this to ensure he, I guess, has a curfew, or what steps are you going to take?
Oh, most definitely. We have implemented lots of boundaries. I'm very active with rights recovery, and Jameson is a part of that. He has a life coach now. As a matter of fact, he just entered UP in Detroit, and he'll be participating every week in several support groups, and also you can't when you get into this what I call a mess, you can't break the mess by yourself. You need a hard village, and so that's what the chosen family is. We're prepared to, like I said, hold his hand, not do it for him because that's not going to help. But hold his hand, make him responsible, like you were saying, because in the end, he is an individual, and I've been a participant for 5 years. My other loved one has an addiction, and that's what got me to today's recovery. And also, I'm a certification for basically federal, so I'm pretty familiar with that now. It's nothing that I wanted to know about, but I'm blessed that I do today. The 3 of us are retired, so we have the freedom of being not at his beck and call, but being of age. So scheduling for workshops, for seminars, for with DARS, there's several recommendations that the caseworker has set out for Jameson, such as Barbara College. But I'll be attending that with them, if that's a possibility. I look forward to that, if that's the best in my services.
And then finally, you testified that Mr. Franklin was scared of the controlled environment. Is that jail, correct? So DDRF is going to be a controlled programming environment. So how can you be sure that he's going to welcome its treatment?
I did a quick research on this program. It's not prison. It's a program, and I shared that first time. What he's scared of is another sexually abuse, physically abused, and leaving him for dead, and a pile of pieces of blood. Me not knowing, and then 3 days later, not recognizing my son, having a sheriff right there, and having the hospitalist tell me that I need to bond him out, or else they're going to kill my son. And rest assured that this program is a safe haven. It's a rehabilitation resource, unlike what he experienced at Schwarz's with the private.
Ray, no further questions.
All right, thank you for giving me some insight. Thank you. Any other witnesses?
May I speak to my client briefly, Judge?
Sure.
We have no further witnesses, Judge. We rest.
All right, State, do you have any witnesses? All right, Norma, recall this for Friday, and at that time, I'll hear argument and I'll make my decision.
For tomorrow, Judge?
Yes.
Okay.
All right, thank you. I'll counsel, this is yours. Renee?
Hello, Judge. Good afternoon.
Hello. On
Hi.
your client, I issued a judge's warrant. Do you have any information on his whereabouts?
Not at this time, Your Honor. No recent contact with him, unfortunately.
Okay, if you have any updates on him, just let me know and I'll reconsider.
Definitely will do, Your Honor. I appreciate it.
All right, thank you so much, and thanks for zooming in.
Of course, Judge. Thank you. Goodbye.
Bye-bye. All right, Martin Gara, you're here for Shepherd.
Yes, Your Honor.
All right, what page is he on?
To Adam, Judge, he came yesterday and I completely forgot.
What's his cause number?
It is, let me get that for you.
All right, so what's going on here?
Your Honor, there was some confusion regarding his date to appear in court, and quite frankly, I was the source of that confusion. Just kind of give you a sequence of events. He had emailed me December 18th, and basically explained that he lives out of state. He has lived in Texas for some time now, and he wanted to see about getting his first court appearance rescheduled. And what had happened was this, when that email was sent to me December 18th, although we didn't actually speak about this until December 29th, at a time when I really was on vacation. But essentially, I conveyed to him, okay, I understand your situation. I'll talk to the coordinator. I think we can accommodate you and get things rescheduled. But at some point, you're going to need to appear in person. Well, what ended up happening was on the 5th, he was scheduled January 5th. To kind of make matters more confusing, I had one other client with the same last name, and I appeared on the 5th on that client's case. That was still, technically part of my vacation time. So I went to court, got that rescheduled, but in my rush, I had ticked off that I'd taken care of Shepherd when I hadn't taken care of both Shepherds. And so I never was able to, I didn't speak before the court date. I didn't speak on that particular court date. And unfortunately, he wasn't there. But he was relying on what I had told him, and he didn't appear. But as a result, that warrant was issued. I'm trying to find out if there's a way we can recall the warrant, perhaps even issue just a summons so we can appear in court.
Court cannot issue a summons based upon his no-show in January. And a NISI has already been issued.
Okay.
So he needs to come to court.
Okay, Your Honor, if I may speak to my client in a breakout room.
Sure. All right, court is calling 2025 CR 0000464 State versus Deandre Coleman. All right, could I have parties announced for the record?
Opinion for the state of Texas. And Andrew Fred, Mr. Cole.
All right, are you Mr. Coleman? Did you review the motion to enter adjudication of guilt and revoke community superintendent first amended motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? All right, so are we still proceeding?
Yes, sir.
All right.
Judge, there's one other thing I think we forgot this morning. The last setting, my client entered pleas of not true to the criminal trespass. Number one, he did enter a plea of true to, I believe, was condition number 2.
Oh, we're gonna go through it again.
Just making sure the court.
Sure, no problem.
General motion to adjudication of guilt. On or about the 11th day of February, 2026, in Bexar County, Texas. Defendant Deandre Lamonte Coleman committed the offense of criminal trespass in violation of number 1.
How do you plead to that? True or not true?
Not true. Violation number 2. On or about the 9th day of January 2026, in Bexar County, Texas, the defendant Deandre Lamonte Coleman was in there illegally used a controlled substance, namely marijuana, in violation condition number 2.
How do you plead?
Moving on to the state court's amended motion to enter adjudication of guilt, violation condition number 1, on or about the 11th day of February 2026, in Bexar County, Texas, the defendant Deandre Lamonte Coleman committed the offense of harassment in violation of condition number 1.
How do you plead to that? True or not true?
Finally, violation condition number 1, on about the 10th day of February 2026, in Bexar County, Texas, the defendant Deandre Lamonte Coleman committed the offense of harassment in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
All right, state, call your witnesses.
Commissioner, at this time, we'll call Ms. Rashawn Abrams.
Would you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Vashon Abrams.
All right, state, you may proceed.
Yeah, Ms. Abrams, how are you employed?
I am the court liaison officer with adult probation for the 187 District Court.
How long have you been in that position?
4 years.
In the course of your employment with that position, did you come across someone whom you now know to be Deandre Lamonte Coleman?
Yes.
You see him in the courtroom today?
Yes.
Could you please point him out for the record? And show him an article code.
The inmate yellow suit.
Yellow?
I mean, orange, I'm sorry.
Record reflected when this was properly identified by defendant. Can you describe to the court how you initially came into contact with Mr. Deandre Lamonte Coleman?
When he was granted probation, I went over his conditions of probation with him.
Do you know when that was, the specific date?
April 23rd of 2025.
Will it specify that you went over all the conditions of his probation with him?
That is correct.
Did he seem to understand all the conditions of his probation with him?
That is, yes.
Did he ask you any questions?
No. And if he did ask questions, I would have addressed them at that time.
Okay, so fair to say that you would not have allowed him to proceed on probation at that point if you didn't understand the terms of.
Correct.
No question, no further questions, I'll pass the witness. Thank you.
That's no question.
All right, thank you.
Thank you.
State, call your next witness.
Yes, Your Honor, state will call Ms. Kylie McGill on the Aguilera.
Yes.
Thank you.
Hello. Hi. Could you raise your right hand for me, please?
Oh,
Yes, that's okay. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Hi, McGill.
All right, you may proceed, state.
Good afternoon, Ms. McGill. What do you do for work?
I'm a caregiver.
Okay. What kind of a caregiver are you?
I'm an in-home caregiver.
Okay. How long have you been doing that?
About 2 years now.
Okay. You do anything else in your life other than that?
I'm also a student,
And what are you going to school for?
a medical assistant.
How much longer until you complete that?
I graduate in December.
Okay. Ms. McGill, have you ever come into contact with someone whom you now know to be Deandre Lamonte Coleman?
Yes.
Do you see him present in this courtroom today?
Yes.
Could you please turn to the point him out by an article of clothing that you're wearing?
The orange jumpsuit.
The record will reflect the witness properly identified the defendant. Ms. McGill, can you please tell the court how you initially came into contact with Mr. Coleman?
I was living in Haven for Hope with my mom and siblings and my daughter. And I met him around June 27th.
You met him when? I'm sorry, I couldn't hear you.
I met up him in Haven for Hope.
Okay, do you remember when that was?
We started officially dating June 27th,
Of what year?
2025.
Okay, so how soon after you met him did you guys start dating?
We officially started dating the 27th, so yes.
How would you describe your relationship as far as dating with Mr. Coleman?
It started off good, but then things got toxic.
Can you describe to the court how things got toxic?
Physical abuse.
I would say about 30 feet, 35.
Okay. No further questions this time, I'll pass the witness.
Any follow-up?
Mr. Coleman? Do you think that your behavior from about 8th or so of February to the 12th or so of February was due to an undiagnosed mental illness?
Absolutely.
And so again, what are you asking the court for today?
Yeah, just ask you to assist to that twice already.
Right, I'll hear it.
And if you could just,
Okay.
nothing further, I think.
For the state is either just argument.
Okay. And
No further
I
witnesses.
have one question, if there's no objection.
No objection.
No objection from the state.
All right. Did you ever ask or report any mental health issues to probation?
Upon doing my tapping eval, it was noted, they documented that I have been spending my last 2 visits in Bexar County in mental pods. And it was noted that I was on Zypraxin for mood swings, and the evaluator did evaluate that I had PTSD.
Okay, but did you ever report any of this to probation? And did you ever ask for help from probation?
Unfortunately.
Okay. All right, this is what the court is going to do. The court is finding violations of 1, 1, and 1 true. The court is finding violation of number 2 not true. Although the defendant did testify that he used marijuana, the court is not going to find that true because there's no evidence other than his admission with regards to a violation of condition number 2. The court is going to grant the motion, find him guilty or revoke. There's an affirmative finding of family violence. The court is going to sentence you to 10 years in the prison, give you credit for any time served, and the court will request the therapeutic community. And what is the complainant's appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction and also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Good luck to you.
Judge, would you consider retaining jurisdiction?
No.
So what does this mean?
All right, State, what is happening with Martin Gara?
Judge, I'm gonna be reviewing the PCIC and CIC, don't have the file down here, but I'll be tendering an offer to get it today.
All right, is this something you are going to take care of today, or is this something we can take care of tomorrow?
We can take care of it.
All right, Attorney Gara, y'all
Yes,
can
sir.
zoom in tomorrow at 9. And my understanding, things will be taken care of at that time.
Okay, Judge, thank you. 9
Right.
o'clock. tomorrow.
Yes, and it'll be the same Zoom link, Mr. Shepherd. And Martin, if you'll make sure that Norma has your client's email.
Will do.
All right, thank you.
Thank you, Judge.
You're welcome. All right,